Welcome to Contracts Law. This will be the first of 3 lectures that we're going to have. First is basic contracts, mostly focusing on those 2 chapters that discuss formation. Second lecture we'll have is on termination, revocation, consideration. And the third lecture is on what I call super advanced contracts, which is when we discuss pricing in the form of antitrust laws, which is in some of your textbooks, regulation of competition or antitrust. But for today, we're going to focus on how to form a contract. Students, if you look in the modules under real estate law, which is in the later weeks of this class, week 12, there's actually a sample in there. And I've marked the 6 first elements that you need to form a contract on that real estate contract, and you can take a look at it. We will abbreviate contracts, not with a C like you would think logically, but with a K. Extra credit for anyone who finds out why. And the 6 basic elements to start with, if you look in the textbook, tend to start with either the letters A or C. First element for a valid contract is competent parties. And more on competency in a little bit, but we do have parties. We'll have we will have like plaintiff and defendant like we've discussed before. But that tends to be when they get into litigation. But you'll have name 1 and name 2 in a contract, and we'll have signature lines with their names. Sometimes, if it's important, in order to signify their competency, we'll also ask for their age. Oftentimes, we'll ask for someone to notarize and validate that the person standing in front of them is a competent party. If you become a notary while you're taking MCC 241, I provide extra credit for doing that. And of course, the assignment is to find the steps necessary to become a notary. After competent parties, we go into the second element, which is assent. That is, did both parties agree? And how can we find that validly in the document? The third element is an agreement. I agree to hire you as my videographer, and I will pay you $5,000 to do it for 20 minutes. You agree to video for me. That is a contract. We will talk about the agreement can either be bilateral, unilateral, executory, personal services contract. Hiring the famous Pete Lilly videographer will be a premium price in this personal service contract industry, as opposed to just hiring anyone that you find on the internet. Those are some considerations in terms of the agreement itself. And then we will get into the fourth element, which is consideration. And there's a whole chapter on this in your book, and we will revisit that in our next video. But what you need to understand about consideration is it is really the notion that both parties actually considered making a deal with each other. So when you pick up a contract, you might see at the beginning of it, it'll say, for and in consideration, $10. And you'll say, but I agreed to pay $5,000 to Pete Lilly. What is that $10? That $10 is an evidence of a handshake. It's evidence that both of you considered what was going on with this contract for videography. It is not earnest money. It is also not a bonus. It is also not a penalty. It is also not a deposit. Consideration is a vehicle that just shows the parties considered something. So if you pull out a bill of sale for a car, for example, or you pull out a bill of sale for a motorcycle, you might see at the top, for and in consideration, $2, $5, $10. Consideration is that just to show that the parties actually knew they were exchanging a benefit and conferring a benefit upon each other. It is not any of those other concepts. And it's complicated to understand. But for now, just know that it's one of the 6 elements that you have to have, or it's not a valid contract. In addition to that, you must have a lawful objective. What does that mean? You cannot write up a contract for prostitution. You cannot write up a contract that is valid for gambling in certain parts of the United States. You cannot write a contract to get someone to murder your spouse. These things are not valid and lawful contract objectives. The last element is in a form required by law. What does that mean? In this class, we're going to study the statute of frauds, which I will get into defining later, the SOF, And the statute of frauds set forth many of the arrangements that must be written up. If you're going to work somewhere for over a year, that's one of the things that has to be in writing. If you're going to buy a house or real estate, that has to be in writing. If you're going to have a contract for marriage, that has to be in writing. That's under the statute of fraud. So, and they will also, many contracts will specify what the form needs to look like. So for example, if you scroll down under your modules and you look at the real estate contract, at the top it will say either the Northwest Suburban Realtors Association or the Multi-State Realtors Association has come up with a form agreement, and that would tell you the form by law. If it does require signature blocks and notaries, that's another formality required by law. So to start with, class, when you do that very first assignment that you're being given under the modules for this week, I've given you 8 topics to choose from. You don't have to do all 8. God bless the student who did one semester. You only need to do 1 of the 8. So perhaps you pick Pete's plowing, which is the first contract, or perhaps you pick Mary Jane's babysitting, or Joe's social media. What I'm expecting you to do at this point in the class, in the first formation exercise, is be able to draft something that has those 6 elements on one of those 8 topics. So you actually, for your memo writing assignment this week, you take a hand at drafting a contract. Random thoughts may wander across your mind while you're doing this, thinking like, well, if I'm going to have Pete's plow, he better have insurance, or he better be bonded. What if he damages my plants? Go ahead and throw that in. Also, from our first week of class, we talked about always putting what is the choice of law. We're in Illinois for these contracts. You can put in a choice of law saying the law of Illinois applies, and perhaps that the court in McHenry County will be the court to adjudicate the case. So those are some additional elements you can throw in for full credit. If you have any of the employment contracts, and we will discuss employment contracts in the 15th week of this class, and real estate contracts in the 12th week of this class, you will perhaps throw in like the person is old enough to babysit, the person is old enough to drive, the person has I-9 documentation. I don't have high expectations that you're going to have all the information that you need for an employment contract in this particular draft, because what I'm asking you to demonstrate in this draft is the 6 basic elements. The other assignment that you have this week, concurrent with drafting your own contract, is one that I like you to do first. I try to give you an engaging discussion forum that will start your mind rolling towards the memo writing assignment. So in this week, I've asked you to look up a case called Colfari, K like our contract, Colfari, not C, versus Pepito's videography company called Carbon 14. And I'm not giving you the link for a reason. I want you to find the case. And the reason why I want you to find the case is because I want you to see how difficult it might have been for Colfari to find out that this videographer was indeed someone she shouldn't do business with. Your discussion assignment then for this week is to give advice to the bride and the groom, potentially. But Ms. Colfari's mistake was simply in 2011, she talked to some friends who recommended this particular gentleman without doing much of a background check. She retained him verbally. He came to the wedding and he filmed, and the videotape and Pepito disappeared. Pepito filed for bankruptcy, and the bride did not have any video memories of her wedding. So I give you a hint that one of the tips that you might give the bride for all personal service contracts and for lots of contracts in general, including construction contracts, is you never hand someone $3,000 as she did up front. You're going to want to give them a deposit. Maybe they require a third, maybe $500 deposit, and then stage payments concurrent with performance. So perhaps you give another third at the wedding, and then you don't give the final third until you get the video back. Having set up that payment structure, however, is not the only thing that she could have done to prevent her problem. So we discuss where are some ways to get reference checks. I also ask that for the purposes of this particular discussion, you go online and find yourself a sample contract, a videography contract, so that you have an understanding of what things you might want to write in. Perhaps she'll insist that he film with 2 cameras. Perhaps she'll ask that the video of the vows be given to you right there at the wedding, so you can take it and look at it on your honeymoon while you wait for the whole video of the wedding and the reception to be given to you afterwards. Again, if you think Ed Sheeran is going to come sing at your wedding and you want to write a contract with him, or you think that Tony Bennett's going to come sing at your reception, those are personal service contracts. Even myself, I thought I had contracted with someone who was on the level of Annie Leibovitz to come to my wedding and take pictures, and this person sent someone who was very junior on their staff and still expected the exorbitant fee that they imparted to us. So if you are insisting that you want Pepito, you better write that if Pepito doesn't come, and then we're going to get into in the second video of this particular lecture, discussing how to write up penalties, contract termination, revocation, bonuses, and things that you could structure. But for your discussion, I want you to focus on what should be done pre-contract, what should be written in the contract, what formation elements need to be there, and take those 2 assignments along with this lecture and quiz. Moving right along into termination issues, which I'm going to foreshadow for you at this point, we want to talk about contractual intent. What if you only intended for the photographer to come just to the wedding, or you wanted him there for the reception and he thought he was just there for the vows? Have we really spelled out in what we call the T's and C's section of a contract, the terms and the conditions, what the expectations were for performance? And have we been definite? If you said, I want you there for the wedding, did you mean you want them there for rehearsal? You want them there for pictures afterwards? Have you really broken it down into every expectation you had and been definite? If you are not definite, interestingly enough, the area of contract law, again, a first-year course in law school, it sets forth that if there is something vague, it's interpreted in favor of the person who did not write the contract. So unlike other matters that we've discussed in this business law class that appear to be unfair, the courts have really looked at who's the person who got taken advantage of, and it should be interpreted to benefit them. And this will apply when we also discuss insurance law, employment law, and real estate law, which are more advanced contract classes after antitrust and contracts. Another termination issue is, was this contract communicated? And what fashion was it communicated? Did it require a signature? Did it say, I'm sending this, would you please sign it and send it back, and it never got sent back? Is it really a valid contract? Were there any counter offers? Was time of the essence? If you said, my wedding is next year and I need the contract signed by this month because I want to have a contract a year beforehand, was there a timing issue under the statute of frauds? Was there a timing issue in terms of signing the contract? Perhaps the videographer, Pete's Videography, is charging $6,000 next year. And so the timing of the contract can also provide an issue that will lend itself towards revocation and termination by its very definition. Other issues that have to do with acceptance, one that we will discuss and you'll see on quiz questions is the matter of who's competent. What is a competent party? What is a minor a competent party? Can a minor make a contract? Contracts with minors can be invalidated. They also can be ratified. So for instance, if I give my credit card to my daughter who is a minor and she goes to the mall and she's with a babysitter of ours and they buy jeans and the jeans are $500 jeans and they bring them home and I think it's too much money and I suggest that they return those jeans, can I call the store and can I break the contract and say that a minor was using my credit card? Yes. I could also say, fine, you can keep those jeans and I'll pay for them on my credit card. Can a person who is intoxicated make a valid contract? Potentially not. Can a person who's on drugs make a valid contract? Potentially not. Can someone who's not of sound mind, who's over a certain age and demonstrating that they have the early signs of dementia, can those contracts also be invalidated for lack of capacity? Yes, they can. Another type of acceptance issue that I was taught at a very young age is the nature of an auction. Do not be confused that an auction has the same rules as doing one of these contracts. If you walk into an auction, as I did with my grandfather in Iowa, and I waved to my cousins, all of a sudden I was bidding on a grand piano. So while you might think that this contracts dialogue that I've given you runs one way, if you go to an art auction, a furniture auction, you need to understand that paddles or raising your hand can be deemed acceptance. Can silence be deemed acceptance? My favorite scenario to give students, and because it's happened to me, it feels very real, is that a neighbor came to my door and he said, "I'd like to shovel your sidewalks in your driveway for $25. And I said, "I got to talk to my husband, I'll get back to you." I didn't get back to him. It snowed. He came and shoveled my sidewalks and driveway. Do I owe this person money for shoveling my sidewalks and driveways? Yes. Why? I was silent when he came and shoveled my sidewalks and driveway. I should have run out there and said, "I didn't retain you to shovel my sidewalks and driveway." He thinks he had an open offer with an unlimited amount of time, and now you have someone who's given you an oral agreement plus performance, and my silence makes it a valid contract. So yes, I did owe them for shoveling the driveway. Another method of dealing with the issue of acceptance has to do with mailbox rules, and we will cover these again in the second lecture. But if a contract, especially the ones for real estate, says that you have to put an acceptance into the mailbox by midnight and you don't, you violated a term of acceptance, and therefore the contract can be void or voidable. That's also how those QVC website purchases work when they say they have an offer open for a certain number of items, or they have an offer open for a certain length of time. If you don't meet those conditions, then you haven't validly accepted the contract. If the contract says that the sale of this property can be signed for by Mary and Jay Jirac, and because we are both the joint owners, then you have to have Mary and Jay Jirac's signature, or it's not a valid acceptance. If it doesn't, if only one person owns the house and only one person is required to sign, and that one person signs, then you do have a valid acceptance. We will discuss in detail mistakes, mutual and bilateral mistakes and unilateral mistakes. But the one thing to tell you that I've run into many times with contracts is if you see two people and they're both making a mistake, is it a mistake of fact or of law to be invalidated? The textbook that you have here, and depending on which edition you have, can be kind of confusing on this subject. But an important thing to know that, like in a real estate deal, I've come across a case where someone actually put the wrong property address down and the wrong county down, but both parties signed. And then you're in a situation where we sometimes employ something called the blue pencil or pen doctrine, which is that you can fix the contract, you can fix the mistake, but again, it depends if they were mutual. And this is also a situation where you see sometimes people taking advantage, and we will discuss that in our termination and revocation lecture more in detail so that you can understand what to do if you're writing a contract and there is a mistake. I encourage you to review chapters 12 and 13 in the editions of Anderson and Toomey, and try to get yourself in a frame of mind where you're working on a contract format to turn in for your assignment box. But first, try to take the principles in that chapter and conduct some business advice to our bride, and we'll see if you understand the basic 6 elements of forming a contract.